afternoon. On behalf of Mr. Christina Duarte, Under Secretary General and Special Advisor to the UN Secretary General of Africa, I'm pleased to welcome you all to this exciting conversation on case studies and best practices on intellectual property, policy making and implementation in Africa. My name is Kabadewa Kashomuse, Senior Economic Affairs Officer and Team Lead, Policy Analysis and Coordination here in OSA. Today's conversation with the members of the Consultative Platform on IP of the OSA Knowledge Network is the second in a series of conversations on various IPR issues of relevance to Africa's Sustainable Development Agenda. The objectives of this series are to, one, raise awareness of the importance of IP among African policymakers, two, to promote information sharing on IP policy making and implementation, and three, to propose IP policy options with a view to advance sustainable development in Africa. This conversation follows the first conversation on building effective patent systems to catalyze local innovation in Africa, which can be found on OSA's YouTube site. The landscape of science, technology, and innovation in African countries presents a huge untapped potential to advance Africa's sustainable development. Since IP protection can provide increased incentives for innovation and STI research, IP protection is vital for advancing Africa's sustainable development. Building on the office's first policy paper on IP, namely the role of intellectual property rights in promoting Africa's development, in the previous video conversations on patent systems in Africa, today's conversation will focus on the case studies and best practices on IP policymaking and implementation in Africa. In particular, case studies will include, among others, the issues of traditional knowledge, traditional cultural expressions, patents, plant varieties rights, and farmers' rights. These are important elements to promote sustainable development in Africa, particularly agriculture, environment, and other relevant industries. OSA hopes that these IP case studies and best practices discussed during the conversation will provide policy options which will help African policymakers to craft effective IP policies and promote their implementation at national, regional, and international levels. We are joined by 4 distinguished experts of the OSA African Knowledge Network Consultative Platform on IPR. They are Dr. Titilayo Adebola, lecturer at the University of Aberdeen, England, Dr. Francis Kariuki, advocate of the High Court of Kenya, and a lecturer at Strathmore University Law School in Kenya. Dr. Charlene Musisa, academic researcher and consultant based in Geneva, Switzerland. And last but not least, Dr. Uchenna Felicia Ugu, lawyer and academic researcher with the Open African Innovation Research Group of the Faculty of Law of the University of Ottawa, Canada. The discussion is moderated by Dr. Musisa. Without further ado, I now hand over to the moderator. Dr. Musisa, you have the floor. Thank you.
Thank you very much, Kava, and thanks to Kai and everybody who has managed to organize this event. I think it's a pleasure for me to be able to speak amongst very distinguished academics from the continent. I always take pleasure when I see amazing women from Africa doing amazing things in the IP space. I'm going to try and see if we can be able to delve into the issues and hopefully have a fruitful discussion. As Kava already said, we're looking at traditional knowledge, we're looking at patents, we're looking at plant variety rights, looking at farmers' rights. These are very key issues, particularly when we speak of agriculture within the continent. And without further ado, I'm going to hand over to Francis, Dr. Francis. I think when we look at the key issues within Africa, we speak of policy making and how can this look like? Because there's a plethora of treaties or conventions that have to do with some of the issues that we grapple with on the continent. And traditional knowledge, so far, we've been unable to have, at least from an international perspective, a treaty that regulates traditional knowledge. So I just want you to speak on the policy-making space, maybe just a bit of a snippet around the background and the context within which we find ourselves, and then how we can be able to move policy around the space and who are the beneficiaries. And then the second question will probably be able to focus on the challenges around crafting or drafting treaties or drafting legislation around traditional knowledge. And then maybe we can think also about replicating what has happened in your case in Kenya, how that can be replicated in other African countries. We don't have, so to speak, any legislation that focuses on traditional knowledge. So Francis, if you can take over. Thank you.
Thank you so much, Shalene, for the welcome, and thank you to the team for organizing this session. As you have said, I will focus on traditional knowledge, and as you have said, this is one of the important areas of intellectual property, which plays a quintessential role in the development of Africa, both culturally, socially, economically, and even agriculturally. And I will start off with, as you said, highlighting some of the issues that pertains to the protection of traditional knowledge, some of the challenges, the beneficiaries, and a few aspects touching on policy making. So as you may be aware, traditional knowledge is basically the knowledge, the know-how, the innovations, the skills and practices that communities in Africa have used over years in terms of their development. And most of this traditional knowledge actually underlies the innovations amongst most local communities in Africa. And it's essential in driving and promoting the development of Africa. And of course, traditional knowledge and the cultural expressions of our people, they are the basis for many decisions, be it in food security, in agriculture, in human, animal health, and natural resources management. And of course, this becomes important even as we'll be discussing about plant varieties, about animal genetic resources, which all underlie farmers' rights. So traditional knowledge has been protected for a long time using the intellectual property frameworks. And those intellectual property frameworks have not been able to adequately protect traditional knowledge, including the institutions that underlie traditional knowledge. And of course, these institutions, which have not been adequately protected using intellectual property, are data repositories and data governance frameworks. They contain important data on agriculture, on conservation, etc., etc. And there has arisen a need at the national level, at a regional level, and even amongst many countries to try and find ways of protecting this traditional knowledge and the institutions that allow for its growth and development. And of course, these institutions and traditional knowledge, they also contain innovative capacities of our people. And if the intellectual property is not able to protect those innovative capacities, then there arises a challenge in terms of promoting innovation in Africa. And so there has to be a way of ensuring that we craft laws and policies that can be able to incorporate the holistic nature of traditional knowledge, traditional institutions across Africa, so that the data they carry, the innovations they carry, can be able to spur our development. When you look at the IP system, it has not been able to successfully protect these innovations by our people. And I will just flag one or two challenges. One of it is the exclusive rights that are granted through the formal IP protection, which are not able to offer the necessary protection and appropriation to TK holders' innovations, which are largely developed collectively. Again, in the traditional knowledge context, there are non-pecuniary incentives, intrinsic motivation, which plays a considerable role in driving innovative behavior, unlike with the intellectual property, where the prospects of exclusive and financial rewards are the main incentives. As such, the use of the IP system by TK holders and some communities faces some constraints in Africa, and there is need to find solutions in terms of creating perhaps more awareness for IP, so that people can find ways of utilizing the IP system in driving the innovation. And so if I look at the Kenyan law, you'll find that in Kenya, we have a law, the Traditional Knowledge and Cultural Expressions Act of 2016, which I considered because it has created a lot of interest in terms of the need for protecting traditional knowledge and cultural expressions. However, if you look at the framework that has been used, is a framework that uses an IP-like system of TK protection. And this, whereas it is advantageous because it offers a sui generis framework, it still fails to recognize the nature in which TK is held across Africa. It ignores the TK's nature as a form of holistic kind of knowledge, which has biocultural, biospiritual, and ecological dimensions. And of course, that becomes important because there is need to try and reformulate or come up with laws that are able to recognize the holistic nature of traditional knowledge, cultural expressions. Again, looking at this law, I note in comparison to other laws, for example, the Zambian law, it fails to give adequate recognition of the customary institutions, the traditional institutions, which, as I said earlier, they are some of the data repertoires which help in the development, in the growth of local innovations. And so that's why I noted that perhaps this is also an area where Kenya, for example, can draw from the Zambian experience in terms of ensuring that the Act gives stronger recognition to those customary institutions. And then, of course, you asked me to comment about the policy recommendations, which we can consider going forward. And I would say that number one, in the African context, as we seek towards protecting traditional knowledge and cultural expressions because of their role in driving Africa's innovation, be it in agriculture, be it in cultural development, conservation, there is need to recognize that our local people, those who hold traditional knowledge, are custodians of TK. And this has to be done in law and policy so that we avoid the mistakes that our country, for example, Kenya, has made. So the IP laws and policies ought to be reviewed to recognize and reflect that TK holders are not owners in the classical Anglo-American sense, but the custodians of traditional knowledge with vested responsibilities towards the knowledge, towards nature, and towards past and future generations on whose behalf they hold the traditional knowledge. Number two, and one of the things which I note with a gap in the Kenyan law is the fact that it fails to give very clear mechanisms on how to protect shared traditional knowledge. Yet across Africa, we have countries that share traditional knowledge. For example, Tanzania and Kenya, with respect to the Maasai's traditional knowledge and cultural expressions. And so there would be need, for example, for countries such as Kenya and others to ratify the Swakopmund Protocol, which gives a framework for cross-border cooperation and administration of transboundary traditional knowledge. And again, here, other countries can draw from Zambia, which gives effect to the Swakopmund Protocol. And number three, there is need to recognize in law and policy those customary institutions in TK protection, because those are the institutions that hold the promise in bridging the gap in TK protection. For example, in contractual arrangements for benefit sharing, it would be good to recognize customary law institutions. And this has been done, for example, in the Zambian Act, which seems to give stronger recognition to customer laws and practices, including outlining the types of benefits that can be accrued in accessing traditional knowledge and genetic resources. And perhaps lastly, I would also mention that there would be need to recognize that traditional knowledge in the African context is holistic in nature, so that any sui generis framework that African nations come up with should recognize that TK holders, of course, are custodians of that knowledge and not owners, and that they hold it within a biocultural, biospiritual, and ecological context, and that such kind of knowledge cannot be easily transacted in the market, just like any other forms of intellectual property. And lastly, perhaps with regards to farmers' rights, and in line with the African position at the global level, there is need to recognize that regardless of whatever system is used in protecting plant varieties, for example, that there is need to recognize that there is a non-commercial use of plant varieties, and the systems of seed saving across Africa is one that should be ensured and protected as a matter of public importance to ensure food security and preserve the integrity of local communities. This would be better rather than seeking to force TK and farmers' rights within an IP framework, without recognizing that there are certain rights that farmers have in the African context that allow for the sharing of plant varieties, their seeds, etc., etc. And of course, lastly, I would mention that there are even guidelines within within the African context, for example, within SADC, which allow for the use of sui generis frameworks and national policies, which can allow for the growth and promotion of farmers and breeders' rights in the African context. So at this juncture, I would pause at this point as I give back to Charlene. Thank you, Charlene.
Thank you so much, Dr. Francis. I think what I have taken from this conversation is around trying to set up a framework that recognizes traditional knowledge and the custodians of traditional knowledge, and also the shared traditional knowledge, that recognition of a transboundary sort of aspect of traditional knowledge. And I'm glad that you mentioned agriculture. I think this will be like a good segue into Dr. Titilayo Adebola's intervention, particularly around farmers' rights. I think what's also interesting for me is the idea that we've got some knowledge, a repository of knowledge that farmers have, with whether it has to do with the seeds that they have, or it has to do with the patterns of agricultural production within Africa. So Dr. Titilayo Adebola, I think we can benefit from the wealth of knowledge that you have, particularly around the discussions that have to do with the international treaties that we've seen come up, and then how African countries can be able to appropriate these very good provisions with more nuances, I think, that are very specific to the continent. So over to you, Dr. Titilayo Adebola.
Thank you very much, Charlene. I'd like to thank Francis as well for the excellent presentation. I think it provides a neat entry point for my presentation on fostering farmers' rights in Africa. I'd like to highlight the importance of farmers' rights provisions in the International Treaty on Plant Genetic Resources for Food and Agriculture. In Africa, farmers are crucial to safeguarding the conservation and sustainable use of plant genetic resources for food and agriculture to ensure continued access to food for our survival. To be sure, farmers provide the seeds and the plant varieties or the source materials for the improved seeds and plant varieties that we rely on, including for food. As farmers' rights are fundamental to protecting farmers' interests, the groundbreaking Article 9 of the International Treaty on Plant Genetic Resources for Food and Agriculture, or the ITPGRFA, sets out the following measures and practices to enhance the realization of farmers' rights. Contracting parties to the treaty should recognize the enormous contribution that local and indigenous communities and farmers of all regions of the world, particularly those in the centers of origin and crop diversity, have made and will continue to make for the conservation and development of plant genetic resources, which constitute the basis of food and agricultural production throughout the world. The ITPGRFA also provides that contracting parties agree that the responsibility for realizing farmers' rights as they relate to plant genetic resources for food and agriculture rests with national governments. National governments should introduce farmers' rights in accordance with their needs and priorities and subject to national legislation. They should protect traditional knowledge relevant to plant genetic resources for food and agriculture, the right of farmers to equitably participate in sharing benefits from the utilization of plant genetic resources for food and agriculture, and the right of farmers to participate in making decisions at national levels on matters relating to the conservation and sustainable use of plant genetic resources for food and agriculture. Importantly, Article 9 of the treaty recognizes that contracting parties should allow farmers the right to save, use, exchange, and sell farm-safe seed and propagating materials subject to national laws and as appropriate. Now, one of the realities of this provision is that many countries, many contracting parties to the treaty have been unable to implement the provision. We would recall that the provision leaves it to national governments to implement. Many countries do not have templates on how to craft or construct farmers' rights, and this has been a limitation to the implementation. Accordingly, the governing body of the treaty established an ad hoc technical expert group on farmers' rights. It was to provide an inventory, views, best practices on how to implement the farmers' rights provisions. The ad hoc technical expert groups offers a comprehensive outline and an inventory on experiences, national measures, lessons on the implementation of farmers' rights. Now, for countries that have not implemented farmers' rights because they are unsure about how to interpret the provisions of Article 9, they can consult the inventory that has been established by the ITPGRFA Secretariat. While the ITPGRFA was the first legally binding international instrument to formally recognize the contributions of farmers to the conservation and sustainable use of plant genetic resources for food and agriculture, we understand that there are similar instruments that seek to protect farmers' interests. For example, we have the Convention on Biological Diversity, We have the Nagoya Protocol on access to genetic resources and the fair and equitable sharing of benefits arising from their utilization to the Convention on Biological Diversity, or in short, the Nagoya Protocol. We also have the United Nations Declaration on the Rights of Indigenous Peoples, UNDRIP, and the United Nations Declaration on the Rights of Peasants and Other Peoples Working in Rural Areas, UNDROP. At the same time, we have certain international intellectual property instruments that provide for farmers' rights, which the implementation could affect the realization of farmers' rights, or could have an effect on the realization of farmers' rights. These instruments include the World Trade Organization's Agreement on Trade-Related Aspects of Intellectual Property Rights, the TRIPS Agreement, and the International Convention for the Protection of New Varieties of Plants, UPOV. For example, Article 27.3b of the TRIPS Agreement provides that all member states of the WTO are obliged to introduce plant variety protection systems. And they could introduce these systems through a patent system, an effective sui generis system, or a combination of systems. In implementing the provision of Article 27.3b, farmers' rights could be introduced at the national level and incorporated in a plant variety protection system, as we see with India's Protection of Plant Variety and Farmers' Rights Act. Although 1 year before India, the Organization for African Unity, OAU, now the African Union, introduced its own African model legislation for the protection of the rights of local communities, farmers and breeders, and the regulation of access to biological resources, or the African Model Law. No African country has fully implemented the provisions of the African Model Law. At the moment, we have the International Treaty on Plant Genetic Resources for Food and Agriculture that sets out provisions on farmers' rights. We have the Convention on Biological Diversity, the Nagoya Protocol, that have provisions on the protection of traditional knowledge, access and benefit sharing, which could contribute to the realization of farmers' rights. We have the United Nations Declaration on the Rights of Indigenous Peoples. We have the United Nations Declaration on the Rights of Peasants and Peoples Working in Rural Areas, which also sets out provisions that promote the interest of farmers' rights. At the regional level, we have the African Model Law. However, at the moment, we still see that African countries have not introduced farmers' rights. However, many African countries are continuing to introduce plant variety protection systems, especially plant breeders' rights systems. They are, in this regard, then excluding or marginalizing the over 70% of their small-scale farmers. Accordingly, I prefer the following tripartite recommendations. First, to recognize and reward their manifold female and male farmers, African countries must introduce effective farmers' rights laws and systems. Second, to craft farmers' rights laws, African countries can consult the ITPGRFA, the CBD, the Nagoya Protocol, UNDRIP, UNDROP, and the African Model Law. Finally, to introduce farmers' rights systems, African countries can draw lessons from India's Protection of Plant Varieties and Farmers' Rights Authority and its Protection of Plant Varieties and Farmers' Rights Law. Thank you.
Thank you so much, Dr. Titilayo Adebola. I think what probably jumped to me is the plethora, if I can put it that way, of treaties that we as Africans need to actually implement, or the provisions that we might need to implement. And I think the existence of an African model law can probably give impetus to how we can be able to craft our own legislation. But I think what you really recommend, the idea of a recognition of the small-scale farmers that we have, the male and female farmers that we have on the continent, and crafting rights that reach out to farmers' rights. I think that's very important. And I think now we're going to move on to Dr. Uchenna, who will also intervene on agriculture. I think what will be very interesting for us is the idea of data protection that comes into play within also having the IP system around agriculture activities. So Dr. Uchenna, over to you.
Thank you very much, Charlie. Well, first of all, I would like to state that the nature of agriculture activity is changing. Data is becoming more important because what happens now is that precision agriculture has come into play that takes cognizance of the specific geographical locations of a farm. Sensors can be put in place theoretically, and you can get information from your mobile phone regarding, oh, this is the amount of moisture in your soil. This is what you need for irrigation. This is what you don't need. These are the markets that you can use. These are the genetically modified crops that would help advance your productivity. Despite this vast amount of information being available, the data has shown that it's not being fully utilized by small and medium-scale farmers, especially in Africa. In fact, the last survey I noticed showed that less than 25% of farmers had access to this type of technology, were able to utilize it for their farming, even though it has the potential to double the levels of production and produce greener agriculture. Why is this happening? We could ask ourselves. The challenge is that whereas this data is generated and is produced by the farmers, the resultant knowledge doesn't actually belong to the farmers. That I would like to explain the three-step process of how data is generated. The farmer puts sensors in his farm, it collects information. That information doesn't actually belong to him. The information belongs to the data collection company, the ICT company, possibly an internet company that collates this data. It might make some observations regarding it. That company can send it to another company and say, hey, this farmer needs this. You should send him adverts regarding fertilizers. Or say, oh, this type of crops do this. This is what you could do. But the farmer himself, the biggest challenge is that the farmer himself does not have access, the right to reassess the data that has been generated regarding his farm, or the conclusions that have been drawn based on the data generated from his farm. In fact, often when if you want to use some digitalized agrotechnology, the contract requires that farmers sign a contract that grants ownership of the data to the collector companies. So without paying a fee for licensing, they can't get back to their data. This definitely doesn't help growth or innovation because it restricts what farmers are able to do. A classical example I'll give is that of the Ubli berry plant in Gabon, which traditionally had been used by farmers to help in the process of weaning their children. It makes them very strong. Researchers from the University of Wisconsin interacted with the local farmers, heard about the assets that the plants bring, and took it back to their own labs, researched it, and identified the protein that is actually causing the plant to be so energizing. They took that protein, patented it, and started selling it as a form of sweetener. And I'll say the whole market of the Gabonese people collapsed in that particular area. The initial data was generated by the farmers, but they were not able to latch into it later or to obtain any benefits. How can this be resolved in the future? Because even agriculture is becoming more and more digitalized. I would say for Africa to be able to latch in and ensure that it's not left out, the first thing we need to do is our policies need to protect the ownership rights of data contributors, along with those of the data collectors and the users of data. You are contributing data. I'll try to see the farmer just as you see the author of a book. He's contributing. He's giving some information. Based on that, he should have the right to reassess any conclusions regarding his data without having to pay licensing or other fees based on that. If you give them ownership rights under data protection laws, along with those who are collecting this data and those who utilize it, that would definitely help out. Clause 2 of the Code of Conduct for Agriculture, developed by the Global Open Data for Agriculture and Innovation, is a good example to utilize because it requires that farmers own the information generated on their farming operations. So that would help them a lot. A second solution would be to allow for open access to agricultural data for research, learning, and innovation. This is generally allowed under different provisions of the CBD, the ITP, GRFA that have been mentioned by my colleague Titi earlier. But what it would do is that open access means that data is available for anyone can access or use it or share it without having to pay to be able to do that. It would also be important to protect local plant varieties. In the area of data, this would amount to creating data banks on local crop varieties that would help indigenous people in adopting environmentally friendly farming procedures. It would help them to use less agrochemicals and to develop better varieties of these local crops that they are actually using. Because it's digital, it would also, another policy that required would be to increase the capacity building for farmers so that they would be able to use agricultural data and technologies. Yes, if you keep buying the technology or the information or going back to the same company for advice, that will be building up costs. But many African farmers don't even have the capacity to use these resources that are available online. If you could build up their capacity, their awareness, public-private partnerships could do a good job in that aspect, in making the farmers aware that this technology is available and also giving them the capacity to continue developing and utilizing it. It's also important to ensure that farmers are active participants in any laws or rules you're making. The African model law, why it's so good is because it was African countries that came together to look at, developing countries decided to look at what type of laws would suit their own environment. This need for contextualization of laws would be also more effective if the farmers are brought into the negotiation process for data protection and ICT regulations. There's a need for balancing of interest. Data companies, the internet or the data collection companies indeed need to continue innovating and make their profit. But at the same time, this should be balanced with the need of access to ensure inclusivity to a large number of people, access and utilization of such technology. Then there should be a need for to place a disclosure of origin of agricultural data obligation in IP and data regulations. For example, in the example I gave of going back to the Gabon experience with the Ubli berry plant, if you say, okay, you obtain this data, you obtain this genetic material, disclose the origin, where it came from, and then based on that, you say, okay, this is where it originated. These people should also need to give their prior informed consent for you to use it. And any benefits that you generate later on, they should also continue to have the right to benefit from the scientific production that you end up producing. That would definitely have solved that problem. And there would be less misappropriation of local data. In conclusion, I would say that digitalized agriculture is a reality. It can't be run away from. And I'm proposing that as long as African farmers since they are active contributors to agricultural data, they should also be considered as owners with rights that they should be able to assess conclusions based on the data generated in their own farms. Currently, let me just add one thing. Privacy laws, which is what is generally used to protect data, do not apply to agricultural data. It's not private, it's in the public. So while about 8 to 10 countries in Africa have laws regarding data protection, these are all based on the principle of privacy. Agricultural data protection is different. It will need to be protected by a different set of rules. If not, without the adoption of such regulations as a proactive measure, the benefits of digital agricultural technology will keep remaining out of the reach of smallholder farmers, and it will not be sustainable.
Thank you so much, Dr. Uchenna. That was very enlightening. I think for me, what was probably something that jumped across is the idea of privacy protection laws over data that's gathered within the agricultural context. That's quite mind-blowing, because you sort of think that the idea of any data that's generated is a privacy issue too, and there should be an attendant privacy issue when you've got any data generated. But this has been very fascinating and very enlightening. I think maybe I'll just love to just pick your brains for just like as a way to sort of like end the session. Maybe I can begin with Dr. Francis. I think I would like to just gather your thoughts around how we can be able to think about transboundary traditional knowledge. I know you reflected just a little bit on what you have within Zambia, but what would be your thoughts around how countries can come together that share traditional knowledge? For instance, like you mentioned within Kenya and Tanzania, how can that cooperation look like, and how can it be inclusive maybe to the beneficiaries of such protection? Just like in a few minutes, what your thoughts would be around that.
Thank you so much, Charlene. That's a difficult question. But I would say there would be need perhaps for greater cooperation, because wherever you see shared traditional knowledge, traditional cultural expressions, for example, in the case of Kenya, Tanzania, communities in South Africa, Botswana, these are one people. They have only been divided by boundaries that were put during colonial times. And of course, that for me would necessitate that perhaps if more and more countries would ratify some international treaties that facilitate that kind of cooperation, such as the Swakopmund Protocol, I think there would be better respect for the continuity amongst communities and groups that, for example, are in the boundaries, and that would allow such jurisdictions that share traditional knowledge not to rely on those national boundaries in separating that which is one, which is a whole. In the same way we see, for example, even in international water courses laws, in international environmental law, where international law really encourages the need for cooperation. So I would say that would be important, and such kind of cooperation can entail a multiplicity of aspects. For example, sharing, for example, on knowledge, best practices. For example, as I was highlighting in my presentation, Kenya, for example, can draw from what Zambia is doing, because in Zambia they have been able to recognize, for example, the holistic nature of traditional knowledge. But having said all this, I think by the end of the day, there is need again to recognize that as we develop the sui generis frameworks, be that the national level, regional level, that there are unique circumstances that attend to different contexts, not only at the state level, but also at community level. And the moment we ignore those uniqueness of traditional knowledge, traditional cultural expressions, again, we will miss out on how these local communities are actually innovating. So yeah, recognizing and taking into account some of those protocols, treaties that allow for cooperation amongst states, but at the same time recognizing that the locus, the place where all these knowledge, innovations, and cultural expressions come from is at the local context. So we ought not to ignore that even as we pursue international cooperation. Thank you, Shan.
Thank you so much. And I'm sorry to put you on the spot. It's just something that came into my mind as I was reflecting on your conversation. And then just Dr. Titilayo, maybe just like as a way to conclude, maybe if you could just reflect on how you think it would look like. So when we look at, for instance, what you have said happened in India, what specific, or maybe just one or two provisions, what do you think would be like an area of emphasis if we were to craft, say, laws that protect farmers' rights within the African context? In just a few minutes. Sorry to put you on the spot too.
That's okay. Thank you very much, Charlene. And I very much enjoyed all the presentation. So thank you to all the speakers. For me, farmers' rights, first of all, would look like recognizing farmers' innovation systems. Secondly, it would include protection of farmers' varieties. Thirdly, it would include provisions on access and benefit sharing. Fourthly, disclosure of origin, prior informed consent. And fifth and finally, the equitable participation on farmers in the governance and regulatory frameworks that are relevant to their livelihoods.
Thank you so much. That was very much on point. And then Dr. Uchenna, just some final comments. I think I love the most what you mentioned about farmers being generators of data. And one of your recommendations was on protecting the ownership rights of the contribution of farmers. Maybe in just a few minutes, reflect to us how you think this could look like within the African continent.
Thank you, Charlie. Farmers, to protecting their right to data would look like a form of the data, internally generated data would need to be protected as a form of property, just like IP is not tangible property. This is an intangible property, but they own it. Therefore, they can access it in future. Benefits that are generated from that internally generated data should also be shared equitably with the farmers. This would go a long way, especially for innovative systems relating to agriculture, whereby they need to go back to the genetic materials. These materials were taken away, would need to say, okay, this is who it belongs to. This is how the benefits can be shared. And it would actually go further in improving the ability of farmers to farm sustainably and to farm in a way that is more environmentally friendly. So it would take, I would say, active participation, not just by the national governments, but by international organizations to be able to bring this about. But it's, as I said, it's not something that we say it's in the future. It is now. And if action isn't taken now, in 20 or 30 years' time, Africa will find that it has been left behind because it can't get this information. Though it's generated on your farm, it doesn't belong to you. In your head, it does, but in practice, it doesn't. Maybe there would need to be an organization to implement and enforce that ownership. Thank you.
Thank you so much. This has been a very enlightening discussion. I think it's very difficult to summarize the contributions that you have all made. I'll probably try to summarize it in a way that I can understand, but it's very difficult because it's a very broad scope of interventions from all three of you, and I'm very grateful that we've been able to have this conversation. So I think what I can probably just, in a minute or so, summarize is there's a need for that recognition. I think most of what Dr. Francis focused on was that recognition of traditional knowledge, the holistic nature of traditional knowledge, and recognition of the custodians of traditional knowledge. And the contribution of farmers or farmers who have traditional knowledge or the knowledge that they possess about genetic resources, about plant varieties, about seeds, about biodiversity, and about the ecology. So I think there is that need, at least from a policy level, a recognition to begin with. And then also when you look at the contributions that came from Dr. Titilayo Adebola, the idea of having farmers' rights systems within the African continent, because they are empowering. These are the producers of most of the plants, seeds that we have, at least within the continent, and they have a repository of knowledge around the agricultural processes within the continent. So introducing a farmers' rights system would be ideal, but how that could look like probably will derive from the number of treaties that we have that govern these kind of issues. And then protection of the ownership rights of data contributors. I think that jumped out a lot to me from Dr. Uchenna's presentation, and particularly around the issue that farmers generate a lot of data, and it is their data that is then used by the people who collect this data and use it for commercial purposes. So there is need for having an ownership structure and an access structure of some sort, and then having open access to this kind of data to enable research and learning and innovation on the continent. I think when we look at it, we require research for us to advance as a continent. And the more we've got access to this research, the more we can have further research and develop further in our agricultural processes, taking into account our different needs within the continent. And then finally, what I think is also very important from Dr. Uchenna's presentation is the idea of disclosure of origin of agricultural data, particularly as we look at the IP system, as we look at the data regulation frameworks, because these are very important issues. One way to protect is to have a disclosure requirement, which will point us to where the data has originated and how it can be accessed, at least for the use of all those who are involved in generating it. So thank you so much to all of you for participating in this conversation. I have had such a great pleasure moderating it. And thank you to OSA for having us. It was absolutely amazing to participate in this discussion. Thank you so much. Over to you, Kay.
Thank you, Charlie. I found your moderation to be fantastic. Thank you.
Yeah, thank you very much, everyone, Charlene, and then all the speakers.